interested in your perspective as a lawyer, as a business lawyer for CMS in with the EU legislation. First of all, you mentioned that you have experience of some 5 years in such matters, in compensations.
Yes, that's correct.
Yes.
Well, within the European Union, basically every member state, and in the Netherlands where I practice, the whole concept of damage actions is relatively new. In Germany, the first action was launched in 2003 or 2004, and in the Netherlands it was a bit later. So that basically means that as a business practitioner, I have been involved in this, say, for 5 to 6 years.
I see. And is there a client base for this practice? Do you see potential in terms of revenue? Is there interest in such matters?
At this very stage, it depends. There's still a number of companies that are very reluctant to go to court and claim damages. But this changes rapidly. Basically, in the Netherlands at least, where the shift is going at an enormous pace. At this point, many companies, also the larger companies, start to develop policies that if they find out that their suppliers have been cartelizing, then they will assess at least if there's a possibility to get the overcharge that they may have paid back from those cartelists.
I see. And the teams that handle such matters within the firm, will you need to create new teams because there is a shift in paradigm? Will you have to work with litigators and competition advisors? Is this a new department, so to speak?
Well, some firms have actually made new departments, but in practice, most firms, and that applies to us as well, we combine the forces. We have the litigators on the one hand who bring in their expertise in civil litigation, and we have the competition lawyers who of course, are indispensable and are often in charge of the case, and they are basically taking things forward. And whenever they need it, they will use the litigation expertise that we have.
And given the choice, would you, as a lawyer, prefer defense or offense? Would you prefer to defend a violator or attack them in the name of a client?
Well, so far, at this stage, one would say I would like to represent the defendant because the chances of winning are higher. But the directive that we've been talking about today is basically going to change that as well. I think soon I will be saying I will also be happy to represent a claimant because it will be facilitated and the chances of winning in court are going to increase without any doubt. Obviously, given the fact that I usually represent companies that are involved in cartel proceedings before a competition authority, it's usually also these companies that I represent in the administrative procedures also ask me to defend them whenever there's a follow-up claim. So for that reason, primarily I work for defendants.
I see. And when you advise a client, will you now have to make calculations in terms of potential losses incurred by their conduct? You might be sued by this company and that company and you could pay this or that.
And that's the shift I've been talking about. 5 years ago, I would not even consider proposing that to a client that is involved in a cartel proceedings. I would not consider that something to address immediately, and now we have reached a stage, and also in light of the directive, where we immediately will see how much damage they may have caused to certain, the most important of their clients and purchasers.
And does this double your billable hours?
No, sadly not. I wish. Usually we will have to engage economic experts, so we will not be involved too closely, and we will pass it on to other service providers. So in that respect, my commercial interest is limited.
I see. And who would handle these calculations? Partner level calculations, or will you use a junior to make the assessment of potential payment?
Partner level.
Partner level. This is a complex matter.
The risks are almost by definition so high that I will be involved myself, and I will make the calls on the basis of expertise of economic advisors or not. But this is, again, we're talking about a substantial cartel, and the exposure for damages is huge. So it's something to be taken very seriously.
And you are coming to Romania, going to other countries along with authorities presenting this directive and the legislation, the changes in legislation that might come up. Is it your feeling that other firms are also aware of these developments, or are you feeling like a pioneer breaking ground?
I don't feel like a pioneer. I think all law firms are aware of this development. But the only thing I can say is that CMS is a front runner because we have been able to establish contact with the unit at the Commission who is responsible, and we've been teaming up in order to, well, to inform as many member states as possible. We've done it in the Netherlands, we do it today in Romania, and we will definitely do it in Hungary and Bulgaria at some stage as well. So there's a number of countries in which CMS is just, well, taking the initiative basically.
Were law firms invited to participate, to consult in the drafting of this directive?
They may have been. There, of course, the whole process of legislation, there have been a number of moments where any person could have given his or her opinion. So law firms may have done that for their clients or on their own behalf. So that's possible. But that has been done in a quite early stage of the legislative process.
Okay, and final question. Romania is, where does Romania rank in the chart of countries you visit? For example, Poland is our main competitor in the region. Have you been to Poland with this conference, with this education action, or will you be going there next? Where is
we are in the process of organizing a similar conference there as well. So that's ongoing. I wouldn't like to make a hierarchy of other countries that would make me feel very uncomfortable. What I notice, and that's the good news, and that's why I'm so happy with what happens today here in Romania, what I notice is that people are already aware that it's something that should be discussed and should get attention, and that, well, in every member state I visit, the process of becoming aware and of thinking about how this should be taken forward is quite intensive.
And speaking of the interest, in that room full of lawyers, do you feel there should have been more questions asked?
No, I think it was a fantastic conference. I think the comments were of a very high level, very pertinent and very to the point. Again, I'm incredibly impressed and excited about the fact that so many people have come to this conference from all different backgrounds. And I think, well, I'm quite excited about the way this is being picked up by the Romanian authority, by the competition authority in particular, and by CMS. So I think, coming from the Netherlands, I'm really impressed to see how things are taken up here, and I would only encourage everyone to continue.
Thank you very much.
Okay.
Thank you.
Thank you.